Thank you. I want to begin by thanking our mayor, Mayor O'Hara. It really says something about our community when our mayor will join us for an event like this in the morning and provide her continued leadership. I also want to thank the Tennessee Commission on Human Rights, or Human Relations, excuse me. Appreciate all of your great work and appreciate the invitation today. I'm here to talk about a slightly different topic. In most people's minds, many of you may wonder why access to civil legal services would be considered a human relations issue. I hope to give you some answers to that in very brief comments this morning, and I will make copies of my comments available on the table afterwards. I'm going to begin with a little bit of a history lesson, if you will, because I think that history is important in understanding where we are today. Our Constitution sets the standard. We, the people of the United States, in order to form a more perfect union, establish justice, etc. And note that established justice comes even before provide for the common defense. Further, we pledge allegiance and state with liberty and justice for all, not just for those who can afford it, justice for all. A long time before we as a nation recognized in a formal way the need to address these core values, private attorneys in some communities scattered across our nation gathered in storefronts with low-income persons and tried to provide civil legal assistance to those poor who could not pay for their services. However, it's important to note that much of this effort was directed to the deserving poor, as defined by those who were giving away their services. In the 60s, many parts of our country saw dramatic civil unrest and even violence. We recognized, among other things, that if a significant part of our population could not use our civil justice system, we had a problem. If the only time poor people saw our civil legal system used was when it was used by someone or some private or government agency with wealth and or power using our legal system to have its way with them. We realized that if that was our situation, we could not expect those people to believe in our system or to trust it, and should not be surprised when people resorted to non-legal means. In 1965, as a part of the War on Poverty, the Office of Economic Opportunity launched its first federally funded legal aid program. In 1974, President Richard Nixon signed into law the Legal Services Corporation Act, creating the LSC as we know it today. Eligibility was determined by income level, not some individual's determination of whether or not the person seeking justice was, quote, deserving, end quote. Judgment would be left to the courts or administrative bodies. Funding for civil legal aid has always been a struggle. But in 1978, Congress established the minimum access goal of funding sufficient to allow one legal aid attorney for each 5,000 eligible low-income persons. Funding across the nation was allocated based on poverty population for each service area. In 1980, the nation took a philosophical turn, and support for federally funded legal aid became a target. In 1982, the Legal Services Corporation saw its appropriation drop by 25%, nearly a third when adjusted for the high inflation rate at the time. 1983 began a period of near frozen allocations with minor increases in the early 90s, and in 2009 and 10, each followed by major funding reductions. In 1996, LSC funding was reduced by 30%. In 2012, it was cut again by nearly 14%. In 1981, the Legal Services Corporation appropriation reached $321,000. For 2014, the appropriation level is $365 million. That made $321 million versus $365 million. Now that is an increase in dollars, but that is after 30 years of inflation and a dramatic increase in the poverty population. If we look at the total inflation since 1981, it equals 105% 0.82%, meaning that LSC funding would need to be 600 million, in 2014 just to keep even with inflation. In 1981, the current Legal Aid of East Tennessee service area had 81 legal aid attorneys. Today, in spite of adding nearly 40 different funding sources, LAET is able to employ only 22 attorneys. 81 to 22. In terms of the congressional minimum access goal set in 1978 of 1 attorney per 5,000 eligible low-income persons, LAET should have resources to employ over 70 attorneys, not the 22 we currently have. Why is this relevant to human rights? To begin with, in spite of our Constitution and pledge, we have yet to ensure justice for all. Studies done by the University of Tennessee College of Social Work, Office of Research and Public Services, combined with other statewide studies, indicate that Tennessee's legal aid programs, including Legal Aid of East Tennessee, have sufficient resources to meet less than 10% of the need for civil legal assistance experienced by persons living below 125% of the federal poverty index in East Tennessee. Other surveys have estimated that legal aid programs are able to assist less than half of the eligible person with civil legal problems that are severe enough and who have the capacity to contact us seeking civil legal aid. In some counties in East Tennessee, Legal Aid of East Tennessee's total funding is sufficient to serve one person per month. We're much better off in Knox County, but still that 10% figure is relevant. Our justice system does provide legal representation to most people charged with a crime, where there exists a risk of incarceration if convicted. However, there is no right to counsel in civil cases, except in some states in some very limited areas, and those areas are under attack. So why is access to a legal aid lawyer for a poor person a human rights issue? In part, it is because there are practically no other resources for justice for them. Access to justice does not merely mean that a person cannot get a particular legal matter resolved. It means that the legal problem will become more critical, will lead to other problems, and will significantly impact the quality of life for the individual and their family. A woman without sufficient resources to hire an attorney, or a low-income man, can be the victim of domestic violence and be being beaten repeatedly and severely, and we will not provide an attorney to protect her. A person can lose custody of her or his children to a spouse who has financial means, regardless of what is in the best interest of the children, and we will not provide an attorney to represent them. A custodial parent can be forced to live without child support because they cannot afford an attorney to represent them. A person can be evicted from their home, whether it's rented or being purchased, can have their home foreclosed upon in violation of clear laws, and we will not provide an attorney to help them. A person can be cheated out of wages or denied unemployment compensation benefits that they are legally entitled to, and we will not provide an attorney for them. A person can be denied medical treatment or insurance coverage for treatment that would literally save their life. And even if they are eligible for insurance coverage, we will not provide an attorney to help them. We recognize that a lawyer is the key to the courthouse door. The denial of civil legal assistance to protect themselves in civil matters, and thus the denial of real access to our justice system, results in physical abuse, homelessness, illness, the perpetuation of poverty, and even death. In many critical cases, the punishment to the just poor person who cannot get representation is far more severe than in lesser criminal cases. We must ask ourselves if it is a human right to be safe from abusers and predators of all kinds, housed, healthy, educated, and fed, and to have access to a fair legal system. Thank you.
You know, you talked about the 22 lawyers that you do have. Then who do they represent? I mean, do they get out there and represent people on the cases?
Yes. Again, those 22 lawyers are serving 26 counties, 350,000 eligible people. Because of limited resources and because of federal requirements, we set case service priorities. Obviously, we can't serve everyone. In fact, in California many years ago, a legal aid lawyer was found to violate the canons of ethics because he promised to serve more people than he could get to. And that would certainly be our situation. We involve the community in priority setting, and currently our priorities include representing people who are victims of domestic violence, and we serve, I think it's a little over 2,000 of those people per year. Preventing homelessness, and that can be an eviction defense or foreclosure defense, depending on the situation. Ensuring that people get those safety net public benefits that you and I pay taxes for, thinking are going to people who are eligible and in desperate need. And that can be everything from food stamps to TANF, which used to be known as the FDC program, to unemployment compensation. And let me mention, one thing that we didn't get to that maybe we should have is there's an incredible, everything boils down to money. There's an incredible economic benefit to providing civil legal assistance. We received a grant to provide representation for applicants to unemployment compensation. Only those, it was from Foundation, only those recently eligible who had been denied in their initial application. So they were headed for appeal. We were given $34,000 to represent those people. And we recovered almost $750,000 in benefits to people who had already been wrongfully denied. Okay? Now, and we want to stress, those people don't put that money in the Caymans. You know, it gets spent. It has an economic benefit. We have another grant where we're representing victims of domestic violence. And much of what we do is obtaining orders of protection and enforcing orders of protection, which is a necessary step in many cases. We received a grant to work with those clients to access the support that they needed to stay apart and independent and safe. And we're only 6 months into the grant. We've spent $20,000 of money that was allocated. We have provided access to $600,000 in support for victims of domestic violence who will be able to move forward, who won't have that pressure to return. We do some consumer protection work, not nearly as much as we want. We have a volunteer lawyer component. Private attorneys in East Tennessee donate their time. They generated about $1.5 million of free civil legal services last year, coordinated through our office. We work with everyone in town and across East Tennessee. You're going to hear from a law student later, and that should be really exciting to you because you're going to find out how much better lawyers are getting than some of us old-timers, so I'm anxious to hear that as well. But that's basically what we do. The hardest part of our job is turning away people that we can't get to. You know, we often get folks who are fairly newly married and the handwriting's on the wall. They haven't been hit yet. They're in a long line behind elderly, pregnant women who are being kicked in the stomach. The stories go on where the threat to the individual and their children's lives are incredibly high. We're not going to get to that person. And yet we know there's very few other places that are going to be able to get help. And we're going to see them later. We'll make all the referrals in the world, and many people we refer to are here in this audience. But we've got to get to the most severely injured first. I hope that answers your question.
people who may be homeless